Good afternoon and welcome to our webinar. I'm James Vann with Vann Attorneys, and we are going to be talking about some of the new business laws that have come into effect or will be coming into effect this year. We are so thankful that you have joined us for this webinar, and we hope it is very helpful to you. It covers a wide variety of topics, as you can imagine. But anyway, we're going to start here in just a minute. If you have questions, you may submit them two ways. You can either email them to us at webinar@vannattorneys.com, or you can use the control panel on the GoToWebinar. So again, we look forward to hearing from you if you have questions. And please plan on joining us on April 24th for our next webinar. So we're going to go ahead and get started, and we're going to be looking at the laws today, or the laws that have been introduced by either the North Carolina legislature or federal that might impact your business. So let's take a look at some of the new laws that we're going to be addressing today. So some of those have to do, as I said earlier, with the General Assembly or Corporate Transparency Act. We're going to be looking at privacy issues as well as use of AI. So let's look at some of the things that were adopted by the North Carolina legislature. As you can imagine, the legislature has been fairly busy, and it's really interesting. They have passed quite a few bills regarding alcohol beverage control and some of the changes. So one of the bills was the omnibus bill, which allows industry members to provide up to $600 worth of retailer advertising for specialty items and product displays per brand. And that's for a company or a group that has a retail permit. And it's up to $1,000 worth of retailer advertising. So you may see this. I know we've done this webinar for a couple of other groups that have convenience stores or restaurants. So you may see this advertising and not know why, but that's sort of the basis for it. Again, bars could be as well, or restaurants. Also, the change allows a restaurant, a hotel, private club, bar, so forth, right, to, that holds an on-premises unfortified wine permit, or a premises fortified wine permit, or a mixed beverage permit, single serving or for fortified wines as well, for consumption off the premises, including delivery of either the mixed beverages or for a delivery service permit. So you'll see, for example, I remember seeing this, that it came into really, I think, effect around the COVID times, but it was more of a temporary addressing of this issue, where you actually can have a beverage delivered to you, right, from or picked up, right, which is really interesting. And thinking about that, so they also have created a mobile bar service permit with a fee of $500 that you can use for bartending services for events. Not sure if y'all have seen any of that yet. I've seen it at a couple of places. The permit authorizes the permittee to bring malt beverages, wine, and liquor onto the premises of a business that's not an ABC permittee, and to serve the beverages to the guest at the event. And it is event specific. So again, something that's pretty interesting, and you'll probably see that more so at events or circumstances. For example, if a restaurant wants to have a special event outside, you might see that as well. So another change, it allows 15-year-olds to work inside for example, a restaurant or bar. They cannot work in a role of involving the preparation, serving, or dispensing of it, but they can work in the premises. That was something that's a little bit new as well. So let's take a look at some of the commercial law updates. So there was a change for predatory roofing and insurance rebate issues. This is, for example, where it requires contracts for residential roof replacement or repair to have a 5 business day cancellation period following an insurance claim denial for the work to be performed under the contract. So this really came into being for storm chasers, right? That's really how it sort of happened or came into focus. But it allows the homeowner to have a 5-day cancellation period when there's an insurance claim denial. So again, something that's I know we've dealt with a lot of issues on the storm chasers, and again, not all storm chasers are the same, but sometimes when there's a storm coming in or has come in and done damage, you get people from all over the country that will just sort of land on that geographical area, and quite frankly, probably take advantage of folks. And not all do it, but there's a big part of it that does do that. Another aspect of the commercial law update was it allows a reseller to possess a manufactured sign, even if the sign is affixed to real property. So if you're in the business of making signs, right? If you make anything else, or if any of your products or equipment or supplies are incorporated into a piece of real, onto or into a project, you can't take it out. However, they did change that and said if you make signs that you can take the sign down. So as long as you're not doing it and breaching the peace. Really interesting that they have allowed this, because this really is contrary to, in the construction world, once your product or material is incorporated into the building or the project, you can't take it away. So this is an exception to that. A good lobbyist is what they had, obviously. Department of Labor had a few changes that are interesting, I think, to some of our clients and some of the folks that are on here today. It allows for electronic communication as a form of notice under the youth employment statutes, the elevator statutes, amusements, and so forth, having to do with just being able to communicate electronically. That has not been the case in the past. So again, they've made that change for a large number of areas, right? For example, the Health Act of North Carolina, Controlled Substance Examination Regulation, so forth. Not all, but those are the areas that they have approved that. They also made a change that it increases the range of civil penalty for a Wage and Hour Act record keeping violation. It was, like, for example, $250 to $2,000, and this new law changed it to where the fines could be $750 up to $4,500. And also the act allowed for communication electronically as a form of notice. So it used to be, I always tell clients, if you got anything in the mail from Department of Labor or having to do with labor issues, to pay attention to it. If you got it by fax or email, that's probably a scam. Well, that's not the case now. They can communicate electronically. So you need to make sure that you're, watching your email and not thinking it's a scam if you've got a potential for a Wage and Hour Act record keeping violation, as well as some other areas for the Department of Labor. There were a few other changes for regulatory reform that we thought might be interesting to some clients. I saw this, I thought it was sort of interesting. It exempts certain employees whose duties are confined to shampooing or blow drying from having to become a licensed barber or cosmetologist. And I was thinking, I didn't know there were people that just did those things. Obviously, I don't I don't go to those kind of places. And maybe some of y'all do, but they don't have to be licensed. So I never knew you could get a license for shampooing or blow drying someone's hair, but I guess now that they've now given that an exemption for that. So it also increases the number of in-class or supervised instruction hours necessary for a license for a body work therapist from 500 to 650. Again, some of our clients deal in this kind of work, so that's a little bit of a change for regulatory purposes. this might impact a little bit of everybody, right? It requires a secondary ticket exchange, a ticket issuer, or a reseller to meet certain requirements when listing a ticket for sale. For example, a concert or some kind of an event. So that again, you might see some of those changes coming about. So one of the other things that we've talked about over the last year was the Corporate Transparency Act. Let me just tell you the short story, and you probably know it. I'm just going to remind you. Right now, that the compliance of that act is on pause, right? So you don't have to send in your information having to do with the Corporate Transparency Act. As you know, many of the U.S. businesses across the country were required to complete and fill out and send in the corporate transparency reports that showed who the owners were of the company. The stated purpose of all that was to combat illicit activity and fraud and so forth. Right now, there is no filing deadline, right? So, and there's no deadline for filing, but also they are not going to penalize companies that have not sent the information in. That, from what we can tell, it looks like they're going to probably change that going forward. Probably will be this year, don't know that. But if FinCEN, which is the Financial Crimes and Enforcement Network, or if Congress changes their mind and they reinstitute the applicability of this act, then you'll probably hear about it. We hopefully will tell you as well. But right now, that's not the case. They are going to look at how to comply with this act. They realized that for small business owners, it was taking a toll on complying with it, right? Taking the information and getting the information submitted. And so thankfully, they put a hold on that. So if you haven't done it, don't worry about it at this point because there's no penalty. But I do encourage you to sort of keep posted to see if that's going to change. We think it will, but we're not certain. One of the other things that keeps popping up is private or privacy data protection. So, I don't know about you, but I want to make sure my information is safe, right? And I know you want to make sure your information is safe. There have been a ton of data breaches, having to do with privacy issues. There was one recently in the medical world that was fairly large. I just heard that there have been a couple of others. There's a company that managed DNA, and it would tell you, what based off what your DNA is, you'd submit it, right, and they tell you what your family history is, kind of thing. Well, they just filed for bankruptcy. And then there's now a race by individuals to try and delete their information that this company has because the company supposedly is going to sell all of their data, which would include people's DNA. And it'll be interesting to see, even though it may be defined from a health standpoint as privacy issues, they probably are going to sell it as what some people are saying. So something to think about. But the privacy data laws that have been enacted recently is designed to protect information that your company collects, right? There's becoming a growing interest by the states and also the federal government. The states are really taking the lead at this point. Businesses obviously continue to be faced with an increasing amount of regulations to ensure that you're protecting that data. And how about you? But you think, I know some of y'all do collect a lot of data on your customers and you maintain that. Again, depending on what kind of industry you're in, you might collect more than others. But think about this, you probably have social security numbers, birth dates, driver's license numbers, maybe financial account numbers. All of that is included, right? If you're in the healthcare world, certainly the healthcare data is, insurance information. All of that is pertinent. So if your business operates in multiple states, you really need to consider what state you're in and where you operate. If you have employees in another state, right? For example, let's just say North Carolina, you've got your main office here, but you have people in Virginia, Tennessee, and South Carolina that are working for you. You've got to figure out what those states, if those states have different privacy data protection acts. The same thing, if you have customers in those states, you've got to know that as well. So I just want to encourage you to be mindful about what that looks like. All right. So what is the state law wherever you operate? All right. What data is your business collecting? How long are you keeping that data? How are you keeping it? Right. Also, something else to be thinking about is the business using appropriate measures to protect the data. And that's an open-ended question, because the standard is going to become, is it a reasonable, marketable protection of how you're maintaining the data and protecting it, right? Does the business have a written plan regarding collecting the data, the use of it, and protection of it? And then also, do you have a plan if there's a breach of the data? So I want to encourage you to, and look, I hate to add things onto your plate, but if y'all don't have a plan about your the data that you collect, how you use it, what you do, and what happens if and when there's a breach, you're going to be behind the 8 ball, because more than likely you're going to have something that's going to pop up. I would highly encourage you to have that written plan. If you need help, let us know. We'll be glad to help you with it. But I want to make sure that y'all aren't caught flat-footed on that, because if it happens, everything starts happening immediately. You also have to give notice to, and depending upon what kind of information is and how large the data breach is, you have to give notice to your customers as well as to the state and potentially federal organizations, depending again what kind of business you're in. So just keep that in mind. And then AI use, right? This is something that I know everybody's talking about, right? And I know a lot of y'all are using it in different ways. We've started using it here a little bit, right? Not much, but we're using it some. We've got legal research tools that we use that are online that now have an AI component to it. We double check it or triple check it to make sure that it's right. And I would encourage you to do the same thing. But it's amazing how businesses are using AI for research, drafting, putting plans together. It's amazing what it can do. I would encourage you to make sure that you're mindful of making sure that it's accurate. Don't just accept it and roll with it, right? That's obviously going to continue to grow. And some areas, some states and some countries now are starting to adopt AI, an AI compliance regulations to guide businesses and how you use that. So if you operate in multiple states, it's really necessary and important to keep up with what the state is doing, but then also look at the Fed. So I didn't realize this until recently, but the European Union adopted a fairly complex and comprehensive act. I think it becomes effective, I think, August of next year, 26. And this is the first real AI act that has been introduced. And a lot of folks are saying they think that's going to become sort of the standard for future AI legislation. Again, we're not going to go through the details of it because I don't think many of our clients are operating in the European Union. But if you are, you need to make sure that you get information. If you need it, we'll be glad to get it and provide it for you. The AI legislation should and will address the risk of use of AI and the impact. For example, think about this: medical devices, healthcare, utilities, manufacturing. That's sort of the big pieces that they're looking at so far. Colorado and California have also passed AI acts. So if you're operating in those states, you need to make sure that you are complying with it. Again, what most of them so far have looked at is the high risk automated decision-making systems that are put into place, right? So if you're in the education world, if HR, employment issues, legal services, insurance, certainly banking, financial services, and you're putting in AI systems for operation, they're looking at what's the risk right? And then what systems are in place and what does that do? So again, if that involves you, any of those areas, the HR might, right? Then you need to be mindful of what those things, what the new laws are. The Trump administration issued an executive order that addressed the use of AI, and this was passed, or not passed, but signed by the president. And basically, the order said he wanted a report within 180 days to give a strategic roadmap for AI compliance. It didn't go into any other greater detail, but that just realize that that's probably going to be something that the feds are looking at this year, more than likely. We really haven't had a whole lot of legislation from the federal level as much as probably being used, but that's probably yet to be seen. So I hope those areas are helpful to you. Again, it's a sort of a big picture items, right? If y'all have got questions, we'd love to hear from you, but I hope this helps you in planning a little bit. The legislature passed a whole bunch of other bills, but nothing specific in some of the industries I think most of our clients are in. But we'd love to, if y'all have a question, we'd love to hear from you. And again, we hope you will plan to be with us on April 24th for our next webinar. Thank you so much for participating with us and letting us help you when the need arises. We hope you all have a great afternoon.